Welcome to Torn, the only podcast committed to exposing the truth about the child welfare system and its devastating impact on families of color, told from the perspective of your hosts, Sonia Johnson and Classie Collinette, two defense attorneys who have over 15 years of experience working in the child welfare system.
So welcome to our listeners to another episode of Torn. I am accompanied today with my sister in the law, Sonia Johnson. Sonia, I will let you introduce yourself to our listeners today.
Thank you, Classie. I'm Sonia Johnson. I am a parent attorney. I defend parents in child welfare proceedings and termination of parental rights cases. I've been doing this work now for a little over 7 years, and I enjoy working with families. But in that time, I have come to believe that the child welfare system as it is currently constructed needs to be completely abolished. And my hope is that through this podcast and other advocacy work that is taking place out there, that we can reach a point very soon where we are talking about a newly imagined child welfare system. Classie, why don't you share a little bit about yourself?
Sure. Thanks, Sonia, for that wonderful summary of who you are. I'm Classie Collinette. I am a defense attorney, racial justice advocate. I represented many families for many years on the front lines in the courtroom, and I consider myself to be a social engineer focused on uplifting Black folks as well as Brown folks and making sure that their voices are heard, and most importantly, that they get access to justice. So that's me in a nutshell.
What are we talking about today, class?
So today we're going to talk about policy change issued by the U.S. Department of Health and Human Services, Office of the Administration for Children and Families, that can potentially have a positive impact on families who are working toward reunification with their children who happen to be in state custody.
So right now, states and county welfare agencies are required to collect child support payments from parents whose children are in foster care. That means that whenever a child is removed from their parents' home and placed in foster care, the federal government will pay that child welfare agency what's called foster care maintenance payments. And the federal government has historically required child welfare agencies to issue child support orders to those families in an effort to collect child support payments to offset the costs that the federal government is spending for foster care. Last year, the federal government, however, changed its policy and is now allowing child welfare agencies to forgo this practice. In fact, the guidance recommends that states implement across-the-board policies that default to foregoing child support orders and only implement orders in very rare circumstances where it has been shown that the obligation will not impede family reunification or what's in the child's best interest. Classie, that is phenomenal news. That is phenomenal progress.
Yes, Sonia, that is phenomenal news. And in fact, in a letter dated July 29th, 2022, Aisha Schomburg, the Associate Commissioner of the Children's Bureau, and Tangular Gray, the Commissioner of the Office of Child Support Enforcement, and these are individuals who are both within the U.S. Department of Health and Human Services. They wrote a joint letter explaining the reason behind this new guidance. And I just want to focus on two lines that I think really encapsulate the importance of this new guidance. The first line is, quote, "It is not in the best interest of any family to be pursued for child support when they have already been whipsawed by economic insecurity, family instability, and separation." Then the next line is, quote, "Reducing a parent's income impedes their ability to engage in reunification efforts, potentially extending the time the child spends in foster care." And Sonia, those two lines are really key because they encapsulate exactly what the families that we work with are dealing with on a day-to-day basis. And of course, the first time we meet them is often when they are experiencing all of these things: family instability, separation. And then you and I both know one of the first questions that they ask us when they come in: how can I get my kids back? If it's a case where the kids have been put in foster care, how can I get my kids back?
Right, yeah.
And so, Sonia, I'm just going to delve into at least one story that I can think of where these child support obligations caused an issue. And in many ways, I believe did impede my client's ability to reunify with his daughter. And I represented a Black father a couple of years ago, and you and I, we can do a whole episode on Black fathers. So I'm not going to get too deep into that. But Black fathers are often ignored and overlooked in our cases. And that's because the world overlooks them and ignores them. That is the narrative that Black men have to deal with. So when they come into the courtroom, it's nothing different. And so I was representing a Black father, and he actually was surprised that he had to pay for this foster care, right? He didn't even want his daughter in foster care.
Right.
And by way of background, this is a father who wasn't part of the reason why his daughter was removed. His daughter was actually living with the mother. So he's a non-offending parent. And then he learns that they're now taking or lodging a request for child support against him. And at some point, he found out that this was happening. And of course, he found out after many, many months had passed. And by the time he found out, there was a notice that he actually was in arrears. And he was devastated. And I remember him asking me, Miss Collinette, how can I get rid of this? I didn't even know about this. Nobody told me about this. I wish I had known. Does the judge know that I'm poor, that I'm trying to make ends meet? And so these are all the things that all of our families have to deal with. So that was a case where, admittedly, I wasn't part of that child support piece. And I just remember him being very, very distraught by it, and me suggesting that he reach out to legal services, as well as reach out to the individuals in the child support office in that particular county. And I tried to help him as best as I could. But you and I both know that we don't have the ability to get rid of someone's child support. And recently there was a push for the same judge to deal with all of a family's issues. So my hope is that at least in New Jersey, that process is being streamlined, because it's the same judge that knows about your child welfare case that hopefully knows that you're poor. And so when they get this notice about the child support, they should be taking that into account. But it was certainly a case that caused undue anxiety, if that's the best way to say it. And also caused my client to then focus on this child support issue when he really needed to be focused on what does he need to do to get his daughter back.
Right. I mean, I had the two cases that come to mind, one very similar to the one that you just told. And I think I've mentioned a client that I had I think I called him John in a previous podcast, but I remember that was a case where, he did not know about his daughter, found out that his daughter was in foster care. Mm-hmm. And, while he was fighting to get custody of his daughter back, he was having to pay, child support that had been imposed upon him by the Child Welfare Agency. He wanted to be able to provide for his child, but the state would not return his child and then made him pay child support for the foster care that she was receiving. I have a case now, unfortunately. This young man was incarcerated at the time that his child was taken into custody and removed from the mother. He got out and then learned that he had accumulated all of these arrears for when his child was, in state custody as a result of the mother's action. Fast forward to, a couple of months ago. Well, actually, it was more like a year ago, I'd say. There was another episode involving mom. The state removed the child again from mom and actually placed the child with my client. My client is still fighting to overcome this arrears that has, this mushroomed to the point that although he has been providing wonderful care to his son, had to make arrangements with a relative to take his child because he could no longer afford his apartment and is presently, the last time I spoke to him a couple of weeks ago, is residing in his car because of the arrears that he is fighting. And what makes it even, more problematic is he did go to court. He did ask for a modification of his child support payment amount. The court did respond, did reduce the amount significantly, but because he had this arrears, and in our state, once the arrears have accrued, their courts will not wipe out the arrears. Right. And so he's dealing with this issue. So right now, as we speak, his child is with a relative and he is living out of his car, trying to take care of the arrears and get his life back together. So what we're talking about here is pretty significant.
Yeah.
And the change in federal policy is huge. Mm-hmm. So what the federal government is now saying is, hey, you state, hey, you child welfare agency, we are no longer requiring you to go after parents to pay for foster care. In fact, the policy, the guidance has been, don't do it. And the policy now is only in extreme circumstances or very specific circumstances should state child welfare agencies go after parents. Because as you pointed out, the commissioner of the Children's Bureau and the commissioner of the Office of Child Support Enforcement understand the impact on poor people who are trying to reunify with their families of these exaggerated, child support payments. So that is huge. That is absolutely phenomenal. I was struck, though, even though this is a positive step in the right direction, Classie, I was struck by the fact that it is really still just guidance. Right. So now each state has to decide what they're going to do about this guidance. Right. Our state, New Jersey, has to figure out whether or not it is going to adhere to this guidance. And I think that's a little interesting, don't you?
Right. I think it limits the ability of the guidance to have any real impact. Something that we used to say a lot in law school was, this doesn't have any teeth. So it's a step in the right direction.
Right.
but it falls short of giving our families, the families that we work with, the guarantee or assurance that this will not happen.
Right, right.
And my fear is states, because they often, what you and I often hear from advocates that work on behalf of the state child welfare agency, they often talk about how they need money for this and they need money for that, and they don't know if they have the funding for this. So while this guidance is certainly a step in the right direction, I'm concerned that states will still say, well, you know what, we don't have another venue where we can get the money that we will now no longer have.
Right.
Or at least we don't have a venue where we could at least request the money that we have been requesting from parents. So it's something that all of us need to keep an eye out on as advocates, and making sure, A, do the state actors know about this guidance?
Right.
And B, if they know about it, what steps have they taken to act in accordance with the public policy behind the guidance, which is to not cause more anguish to families, right? To avoid this thing called adding on to economic insecurity, family instability,
right,
and then potentially extending the time that a kid stays in foster care.
I mean, one of the things that I think we can do as advocates, because I'm starting to do this in my cases, we're not retained to represent our clients in child support proceedings, but to at least bring it to the attention to the child welfare judges. And, in some instances, if we can work with our clients to file on their own behalf, to say to a judge in a child support proceeding, there has been this guidance. I'm asking the court to relieve me of, additional child support payments in reliance on this guidance. And as an advocate or as a social justice engineer, to try and bring this to the attention of people who are in a position to take action so that this doesn't happen. So I know in my spaces and places that I am in, I have elevated this so that certain people who are in positions to make this a permanent structural change in New Jersey will do it. So we can do that as advocates. We can elevate this, bring it to the attention of people, and encourage people to take whatever action they can in their states to make this a permanent position that we take in child welfare, child support proceedings.
Absolutely. And Sonia, as we're talking about this, I'm getting the feeling that this may become a workshop that you and I can help facilitate, because I don't think that there's enough folks that know about this guidance, even though it is from July 2022. I have not heard this in any of my circles, and I'm concerned that a lot of folks that should know about it don't know about it. And then I'm also concerned that there's a lot of judges that don't know about it, that if they knew about it, they would actually refer to it and say, actually, I'm denying your request per the guidance from the federal government, specifically the Commissioner of the Children's Bureau, the Associate Commissioner of the Children's Bureau, as well as the Commissioner of the Office of Child Support Enforcement for the United States. So I think this is something that a lot of folks don't know about, but they should.
So certainly, and I'm all for if you want to talk a little bit more about perhaps doing a workshop, but I think in the short term, trying to figure out how we can best help our clients, because I do think this is going to may require a legislative action. I can imagine that some folks will take the position that until the legislature acts, that they can't act. I don't necessarily agree with that. I think, that the federal guidance is pretty clear, but until we perhaps get some legislative action on this front, we may need to just encourage people to do the right thing based upon the guidance,
Right. Yeah. Yeah. And Sonia, I know you had covered some of the barriers already that have to be overcome. Were there any other barriers that you wanted to talk about that need to be overcome?
I think you alluded to it earlier, that in our state, it's supposed to be one family, one judge, so that if there is an issue that involves one family, be that a child welfare issue, be that a domestic violence issue, or be that a child support issue, that the same judge hears the case. That works sometimes. It doesn't always work. Work in the sense that I've seen cases where that's not the case. I think there is a policy out there that folks are aware of, but it's not always put to practice. In this context, in the child support context, one of the problems that I see is that parents have to file an independent application to address a child support issue. So what I mean by that is, if I'm representing a parent in a child welfare matter and they have outstanding child support obligation, the judge who is hearing the child welfare order doesn't then just say, okay, let's take a look at the child support obligation. If the parent wants to address it, the parent has to file a separate application to request that the court make a modification. That doesn't seem like a big deal, but then when you are in financial stress and
Right.
you have to go and you have to file something, and then you have to wait for it to get on the calendar for the court to hear it, that becomes a problem. And I think it's a problem that doesn't need to exist. I think if it's one family, one judge, and you have a child welfare matter, and the client or the representative of that parent says, there's an outstanding child support issue that is interfering with my client's ability to either engage in services, get to services, and or be reunified with his child, that child welfare or that judge be able to address that then and there without the parent having to file an additional application and wait for it to be scheduled. So I think that's one hurdle that we also need to address, an additional hurdle that we need to address.
Yeah. Yeah. No, thank you for that, Sonia. And finally, I'm going to round us out with our tips. The main one today is really for folks who are listening to have a talk with their state legislators about ending the practice of requiring impoverished individuals to pay for child support. We need folks who have the ability to make changes that have quote unquote teeth, not just guidance, but actually implementing laws that are actually going to have to A, be followed, and B, help give our families, the families that we work with, some relief. Because I don't think any of us from a public policy standpoint want poor families to feel overburdened, but that's exactly what this child support issue does to those families.
So that's good, Classie. And I think just a tip overall is we will leave links to the letter that you read from, as well as another report from the Center on Budget and Policy Priorities as an overview of the guidance that the federal government has just issued with regards to this. And we encourage, whether you are a advocate or if you're even a parent dealing with a child support issue to become familiar with the guidance and to educate people that you are working with about the guidance that the federal government has issued in and around this topic.
Yes. Thank you to everyone for listening, and we will connect with you again soon.
The opinions and views expressed on this podcast are those of its hosts and guests and represent our own lived experience. The views and opinions expressed do not reflect those of any agency or organization with which we may be associated.